ஹலோ எவ்ரிவன், வெல்கம் டு அவர் சேனல். இன்றைக்கி நம்ம வீடியோவில் பார்க்க போகிறது ஆல் இந்தியா பார் எக்ஸாமினேஷனோட லாஸ்ட் மோர் தென் 10 இயர்ஸோட கேஸ் லா MCQs தான் பார்க்க போகிறோம். லெட்ஸ் ஸ்டார்ட். ஃபர்ஸ்ட் ஒன், இன் ஃபேமஸ் கார்லில் விசஸ் கார்போலிக் ஸ்மோக் பெயில் கம்பெனி 1893 1 QBD 256, the Honorable Court held that the contract was accepting on being. Correct answer option B, acted upon. Next question, number 2. In a Rex vs Govinda, the point of distinction between the two provisions of the CPC were explained. Correct answer option C, section 299 and section 300. Next question 3. The Supreme Court has held that an advocate cannot claim a lien over a litigation file entrusted to him for his fees. Professional can be given the right to withhold the returnable records relating to the work done by him with his client matter on the strength of any claim for unpaid remuneration. The alternative is the professional concerned can resort to other legal remedies for such unpaid remuneration. Refer to the specific case. Correct answer option A, R.D. Saxena vs Balram Prasant Sharma. Next question, the DNA test cannot rebut the conclusive presumption envisaged under section 12 of the Indian Evidence Act. The parties can avoid the rigor of such conclusive presumption only by proving non-access, which is a negative proof. It was so held in which case? Correct answer option A, Sheikh Fakhruddin vs Sheikh Muhammad Hassan, AIR 2006 AP 48. Next question 5. If an accused is charged of a major offence but is not found guilty thereunder, he can be convicted of minor offence if the facts established indicate that such minor offence has been committed. It was so upheld in which case? Correct answer option B, State of Himachal Pradesh vs Taradutta. Next question 6. Provision of section 195 of CRPC are mandatory and non-compliance of it would initiate the prosecution and all other constitutional order, in which case the court upheld so. Correct answer option A, C. Muniappan vs State of Tamil Nadu. Question number 7. The doctrine of legitimate expectation was discussed in the following case. Correct answer option D, Food Corporation vs India vs Mr. Kamathenu Cattle Feed Industries. Next question 8. The Supreme Court in Selvi and others vs State of Karnataka held that compulsory brain mapping and polygraph test and narco analysis were in violation of the following articles of the Constitution. Correct answer option D, Article 20 and 21. Next question, the passive euthanasia is permitted in certain cases held in. Correct answer option A, Aruna Ramachandra Shanbag vs Union of India. Next question, A's nephew has absconded from his home. He said his servant to trace his missing nephew, but when the servant had left, A then announced that anybody who discovered the missing boy would be given the reward of rupees 500. The servant discovered the missing boy without knowing the reward. When the servant came to know about the reward, he brought an action against A to recover the same, but his action failed. It was held that servant was not entitled to the reward because he didn't know about the offer when he discovered the missing boy. Name the case on reading the fact. Correct answer option A, Lalman Shukla vs Gauri Dutt. Question number 11. The commencement of arbitral proceeding is not dependent on interim relief being allowed or denied under section 9 of the Arbitration and Conciliation Act 1996. Supreme Court in which case held so? Correct answer option A, Fim Ashok Traders and another vs Gurumukh Das Saluja and others. Question number 12. Contravention of Contract Labour Act would not create employment relationship between contract labour and principal establishment. It was held in which case? Correct answer option A, SAIL vs National Union Waterfront Workers. Question number 30. A teacher is not a workman falling under the category of Workman under Industrial Dispute Act 1947. This was upheld in which case? Correct answer option A. Miss A. Sundarambal vs. Government of Goa, Daman and Diu and others. Question number 14. Bear on enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of accident in the operation of such hazardous or inherently dangerous activity resulting, for example, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exception which operate via the tortious principle of strict liability held in the case of. Correct answer option B. Steeram food and fertilizer case. Question number 15. A 7-member bench of the Supreme Court unanimously struck down the Class D of the Article 323A and Class 3D of Article 323B of the Constitution relating to tribunal, and which excluded the jurisdiction of High Court and Supreme Court. The court held that the power of judicial review over legislative action is vested in the High Court under Article 226 and in the Supreme Court under Article 32. This is an integral part of the basic structure of the Constitution. Name the case. Correct answer option A. L. Chandrakumar vs. Union of India. Next question. 16. Where two parties have made a contract which one of them has broken the damage which the other party ought to receive in respect of, such breach of contract should be either such as may fairly and reasonably be considered arising naturally, that is according to the usual course of things, from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of the parties at the time they made the contract as probable result of breach of it, in which case the principle was down. So correct answer option D. Hanley vs. Baxandley. Question number 70. Intention not to create a legal obligation was clear from the conduct of parties which among the popular case deals on the topic. Correct answer option A. Baffler vs. Balfour. Question number 18. Ratilal vs. State of Bombay is a popular case on the point of. Correct answer option D. Doctrine of Cyprus. Question number 19. Referring to Section 6 of Hindu Minority and Guardianship Act, the Supreme Court observed that the word after him doesn't mean after the lifetime of the father. Indeed, it means in the absence of. If the father is not functional as guardian for various reasons like indifference, physical or mental incapacity, away from the place where the child lives with the mother by mutual understanding, it may be treated as the absence of the father, in which case. Correct answer option C. Geeta Hariharan case. Next question. Shamim Ara vs. State of Uttar Pradesh relates to. Correct answer option A. The condition precedent for a Muslim husband for rendering divorce in the pronouncement of divorce, which has to be proved on evidence. Question number 21. Ashby vs. White is an example of. Correct answer option C. Injuria sine damnum. Question number 22. The Supreme Court of India invoked the principle of absolute liability on enterprise carrying on business with the hazardous and inherently dangerous toxic chemicals in. Correct answer option C. Steeram fertilizers case. Question number 23. Passive euthanasia under certain circumstances is permissible held in the case of. Correct answer option A. Aruna Ramachandra Shanbak vs. Union of India. This question is repeated again. Question number 24. It was held by the Supreme Court that the balance between fundamental rights and the DPSP is the bedrock and the basic structure of the Constitution, in which case. Correct answer option B. Minerva Mills vs. Union of India. Question number 25. K.C. Kajabadi Narayanan Dio vs. State of Orissa is often quoted with reference to. Correct answer option C. Doctrine of colorable legislation. Next question 26. Raja Ram Pal vs. Honorable Speaker Lok Sabha deals with the correct answer option B, privileges of the legislature. Question number 27. Dash was a leading case on the point as to whether an employer has a right to deduct wages unilaterally and without holding an inquiry for the period the employees go on strike or resort to go slow. Correct answer option A, Bank of India vs. T.S. Kelvala and others. Question number 28. Gloucestershire Grammar School case is a leading case to explain the correct answer option C, damnum sine injuria. Question number 29. Pollution is a civil wrong by its very nature. It is a tort committed against the community as a whole. A person therefore who is guilty of causing pollution has to pay damages compensation for restoration of the environment. He has also to pay damages to those who have suffered loss on account of the act of the offender. Further, the offender can also be held liable to pay exemplary damages so that it may act as a deterrent for others not to cause pollution in any manner. However, the court cannot impose any pollution fine in absence of any trial and finding of guilty under the relevant statutory provision. This observation was made in correct answer option A, MC Mehta vs. Kamalnath. Next question 30. If an accused is charged of a major offence but is not found guilty under he can be convicted of minor offence if the fact established indicate that such minor offence has been committed. It was so upheld in which case? Correct answer option B, State of Himachal Pradesh vs. Dharadutta. Question number 31. In which case the Supreme Court held that Part 1 of the Arbitration and Conciliation Act would equally apply to international commercial arbitration held outside India unless any or all provisions have been excluded by agreement between the parties. Correct answer option A, Bhatia International vs. Bulk Trading SA. Question number 32. The concept of privity of contract was rejected in correct answer option B. Question number 33. Accountability of medical professional and the need for qualitative change in the attitude of the medical service provided by the hospitals was emphasized by the Supreme Court in which of the following cases? Correct answer option B, Indian Medical Association vs. VP Shanta and others. Question number 34. The question whether the fundamental rights can be amended under Article 368 came for consideration first time in correct answer option A, Shankari Prasad vs. Union of India. Question number 35. Equality of opportunity admit discrimination with reasons. It was observed by Apex Court in correct answer option A. Thanks for watching this video.